As part of the learning process, teachers often use copyright materials to instruct students. In this video, we will go over the ins and outs of copyright and copy wrong. What you will learn in this video. We will identify the legal and ethical considerations involved in using others' creative work. We will learn about the selection and use of supplementary instructional materials and resources for the classroom. And finally, we will identify the guidelines for showing video segments, clips, and full-length videos in the classroom. The internet has completely changed how we access information and resources as teachers. You can access at your fingertips more helpful media to assist you in your teaching in a single day than most teachers use to find in a lifetime. But which of these medias can you legally use? There are 3 types of licenses for creative work: copyright, public domain, and Creative Commons. We're going to take a look at each. Copyright applies to any creative work as soon as the work is created, whether or not it is licensed through the U.S. Copyright Office or even if it has a copyright symbol on it. As soon as someone creates a new song, video, lesson plan, book, photograph, presentation, or another resource, that creative work is automatically copyrighted, whether the creator wanted it or not. This means that, in general, you must assume that everything you will find online or offline is copyrighted. The copyright law protects the creator's right to decide how their work will be copied, shared, performed, or displayed. Let's begin with 5 main rules. Just because you found something online doesn't mean it is free, even if you are a teacher. There are a lot of resources that you can use freely, including work that has a Creative Commons license or is in the public domain. You have a right as a creator to have your work protected from copying, and you can also give your own content a Creative Commons license. If in doubt about using content, ask the creator for permission. Find a free alternative, make your own material, or purchase an alternative that has the usage rights you're after. Finally, and most importantly, instead of looking for loopholes, consider whether you're being the most responsible and ethical digital citizen you can be. But wait, aren't you allowed to use copyrighted material as an educator? Sort of, but under restrictions. Fair use is an exception to copyright law that allows anyone to use copyrighted materials without permission if they follow certain requirements. It is not a get-out-of-jail card for teachers. It does not mean that teachers and students can use whatever they want, whenever they want. You must follow copyright law.
When we go on the internet, it's common to scroll through other people's images, videos, writing, and artwork. We might even want to use them for projects in school or at home. And we might think, I found it online, so it's mine. But that's not the case. We can't treat things we find online like a free-for-all. The good news is that there are legitimate ways to use material we find online. But first, we need to be aware of 3 concepts: copyright, public domain, and fair use. Why is all of this so important? For one, there are legal reasons for protecting everyone's creative work. And there are also ethical reasons to give credit to the people who create the things we see and find online. Let's start with the legal reasons why we should think twice before copying and using someone's work. The first is copyright. Copyright is a legal protection that creators have over the things they create. Copyright requires people to get permission before they copy, paste, alter, or share what someone else has made. Most things that we find, download, and copy and paste from the internet are copyrighted. This means that the people who created them own the content and have a say in how they're used. But that doesn't mean that everything on the internet can't be used. Some creators indicate that their content is okay to be used by others, and other content might fall under what's called public domain. Let's look at what public domain means. When we search for content that's in the public domain, it means these creative works are not copyrighted and are free to use without permission by anyone, however they want. According to US law, some content becomes available as public domain after a certain number of years have passed since its creation. There are also specific images and documents published by the government that are considered public domain. So, when in doubt, search public domain to find a ton of things that are totally free to use. Now, if we want to use a photo, a video, music, or other content that's copyrighted, there are still a few things we can do. We can simply reach out and ask the creator for permission. Many creators are happy to give permission to reproduce their work, as long as they're given credit. The third concept to take advantage of is called fair use. Fair use allows us to use copyrighted work without permission, but only in certain ways and in specific situations. These conditions involve 4 areas to consider: amount, purpose, nature, and effect. First, we can only use a small amount of the original work. This means someone can't copy the whole copyrighted song in their dance video, but they can use a short clip of it. Second, there has to be a new purpose in the project, meaning that we transform the original work into something new and different. Next, it's easier to claim fair use if the nature of the original work is non-fiction or based in fact, rather than creative or fictional. And finally, we need to ask ourselves whether the effect of the new work negatively affects the creator or the value of the original content. For instance, are we charging for or making money off someone else's work? Claiming fair use is determined on a case-by-case basis, but it's more likely acceptable if it's 1. For schoolwork and education, 2. For criticizing or commenting on something, 3. For news reporting, or 4. For comedy or as a parody of something. We can think of fair use kind of like a square, and ask ourselves, is it fair and square? So that's the legal stuff. But let's not forget the ethical considerations when using content found online. Think about it. If you created something original and put it online, wouldn't you want others to give you credit for your work? What if they changed it or made money off it and no one knew you were the original creator? That's just not right. So remember, when we go online in search of things to use, keep these 3 concepts in mind: copyright, public domain, and fair use. We're all creative thinkers and creators, and it's always important to give credit where credit is due.
Next, we're going to talk about the selection of materials you use in your classroom. Whether it is a worksheet, video, piece of music, or book, think about how it fits into the curriculum and how it will impact our learners. Think and closely examine every piece of content you put in front of your students. The district has gone through the process of selecting instructional materials that support our curriculum. Teachers are expected to follow this curriculum. However, teachers often use what are called supplementary materials. What are supplemental materials? These are materials that address only a small part of the course content, materials that are read or used by only a portion of the class, or that are used in conjunction with a core text to provide differentiated instructional materials to those students that need them. The selection and use of supplementary instructional materials and resources should only be selected to support and not replace instructional materials that have been adopted as part of the component of the district standard curriculum. All instructional materials and resources must be used in accordance with current copyright laws and licensing agreements. You may use brief and relevant video clips in your instruction that support particular academic standards, curricular goals, or objectives, However, using full-length videos or other media to passively occupy students is not allowed. Finally, the use of sources like Teachers Pay Teachers is not supported. The use of videos and media. If you and your team decide to use a full-length video in your classroom, permission must be obtained from your building principal. Ask your library media specialist or school secretary for a video approval form A, shown here in the picture. This form will ask you if you have previewed the entire video. It will ask you if you plan to show the entire item or just specific clips. It'll ask how much time you plan to use out of class. It will ask for the curricular connection. And finally, it will ask for what alternative activity you will have planned for students whose parents do not give permission for the video to be viewed. You also need to follow the guidelines identified for parent permission if the video is not owned by the district or if the video is rated higher than allowed by the guidelines. In general, written notice to parents and guardians is not required for media rated at the level considered age appropriate. This means rated G for elementary students, rated PG for middle school students, or rated PG-13 for high school students. You do need to get parent permission using Form B, pictured here, and receive prior permission to show a video recording that is rated PG with elementary students, PG-13 with middle school students, or is rated R with high school students. Unrated commercial or independent video recordings released in 1968 or later, or video recordings that have an NC-17 or an X rating may not be shown to any students at any school at any time anywhere in the district. Digital media, data, privacy, and digital instructional materials. We're going to talk a minute about privacy and data relating to students' personal information. Any site using a student's personal information and/or data, which would include things like email addresses, name, age, birth date, etc., should be approved by the district. This is a process that centers around student data. If you would like to request a new app site or digital resource that collects student data, please complete a request form in our new online app management tool called the Learn Platform. The link can be found on MySP starting August 13th. We're going to take a minute and talk about data and privacy.
Computers and the internet have changed the way we live and learn. Educators in some prairie schools have embraced new technologies and are using them to improve education services and instruction. That gives us an immense responsibility for protecting student privacy when using online educational resources. Because no matter where student records reside, they must still be protected. Follow along to explore best practices for good data management when using online educational apps and services. Then, we will investigate how you can protect the privacy and security of student data when using these types of services in our schools and district. Before using educational apps or services, it is important to learn about the variety of federal, state, and local laws that impose requirements and restrictions on how student data can be used, and the conditions under which it can be shared with application developers or online service providers. Let's examine some key privacy laws that may apply. The first is the Family Educational Rights and Privacy Act, or FERPA. FERPA is a federal law which protects the privacy of student education records. FERPA restricts how PII personally identifiable information from education records may be released without the parent's consent. FERPA may allow schools to disclose certain information, like students' name, date of birth, or photos without consent as directory information. This is often done in school yearbooks and athletic programs. A school may provide directory information without parent consent to third parties, like service providers, only if they publicly notify parents about their directory information policy. This notice has a number of requirements, like it must state what personal information is considered directory information and that parents have a right to opt out. But be careful, because parents can opt out at a later time, so using directory information with online services can be tricky. In Sun Prairie, we define directory information as information that includes a student's name, address, telephone listing, date and place of birth, major field of study, participation in officially recognized activities and sports, weight and height of members of athletic teams, dates of attendance, photographs, degrees and awards received, and the school name most recently attended by the student. This information for parents can be found on our district website. Another FERPA provision that permits PII from education records to be disclosed to third parties without consent is the school official exception. Schools often use this exception to outsource IT and other institutional functions, like the way we use Infinite Campus. This comes with expectations that the district is able to retain direct control over the use and maintenance of the information it discloses. Sorry, FERPA isn't the only federal law in question. Let's briefly review a few others that might apply. Another law is the Children's Online Privacy Protection Act, or COPPA. It applies to websites, apps, and online services that collect information from children who are under the age of 13. COPPA requires verifiable parent consent prior to collecting personal information from children online. In some cases, like when a student must use a website or an app for school, and there is no commercial purpose, COPPA allows schools to exercise consent on behalf of parents. In addition to FERPA and COPPA, other federal laws may apply, like the Protection of Pupil Rights Amendment, or PPRA, and the Individuals with Disabilities Education Act, or IDEA, that may impose additional requirements on your use of online apps or services. You may wonder, does FERPA allow schools to share PII from education records with online service providers? Yes, FERPA does allow you to share PII from education records with online providers in some instances. With prior written parental consent, it's always acceptable to share PII from education records through the directory information exception and under the school official exception. But remember, officials can use only PII from education records to perform the specific service or function you directed them to provide. We reviewed how FERPA protects students' education records, but the truth is that FERPA may not apply to all of the data collected by online service providers. That is why you must pay close attention to written agreements, contracts, and terms of service. Increasingly, online services and applications use a licensing model known as click-wrap, where you can sign up by simply clicking a button or a checkbox to accept the terms of service. This could lead to potential problems. Meet Mrs. Jones, a high school teacher. She just found a new app to help kids with math through games. Her students love to play games, and the app is free. More and more teachers like Mrs. Jones are making use of apps and online services. Many providers offer innovative and helpful content, often for free. But be wary that sometimes the saying "nothing is free" might apply. Some apps require the acceptance of terms of service. These can be long, boring, and full of complicated legal language. Mrs. Jones needs to fully understand what she is agreeing to in the terms of service. We may not think of clicking an accept button as the same thing as signing a written contract, but they can be legally binding agreements. For these reasons and more, we expect that all educators follow our digital data and privacy procedures before signing up for an app. Technology in classrooms can improve education by expanding our knowledge, communication, and productivity. But as we enjoy these tools, we must be mindful of the risks they bring and follow best practices to secure and protect students' private information.
If you would like to request a new app, site, or digital resource that collects student data, if you do not find it approved on the platform, you will need to complete a request in our new online app management tool called Learn Platform. The link can be found on My SP starting August 13th. Learn Platform. Find the name of the tool or the app that you would like to use. Read about the safety concerns, and then request it by filling out the online request form. The tech department will work to vet it for privacy, data, and instructional purposes and push it out to your devices. The good news is many of the popular sites are already approved. You will see these on the Learn platform listed as approved, approved with stipulations, or approved and supported. Approved and supported is green, and what this means is that the district has approved it and we support it through financing and or offering training and professional development to teachers. Yellow is approved with stipulations. This means that the district approves the app, but students under a certain age will need to sign a permission slip. We will give you more information about this at Camp Cardinal. Blue is approved for use. The district approved it, but training and financing are not offered at this time. We do have some that are not approved. One in particular is Prezi. Students cannot use this site. Remember, this is all about using good sound practices. We want you to know exactly what you are putting in front of kids. Thank you, and let me know if you have any questions. You can email me at kmschaa@sunprairieschools.org.